In this matter, on September 16, 2019, on September 23, 2019, the jury returned a verdict of guilty to the charge of murder in the first degree. The defendant has filed a motion for new trial and motion in arrest of judgment, filed on November 4, 2019, and a second motion on February 28, 2020. The second motion was filed with the court's approval as to timeliness. The state has filed responses to those motions. The matter is scheduled today for hearing on the defendant's motion for new trial and motion in arrest of judgment. I have read and printed the motions, the state's responses. I will say for the record that all of the pleadings by both parties will be considered as part of the record today for purposes of post-trial motions. Counsel can make argument on those motions and supplement them at this time if they would like. Mr. Hamrock, it is your motion. Do you want to go first?
Thank you, Your Honor. May it please the court, counsel, and Mr. Mullis. Judge, we did file a brief in this matter. I'm glad that you've incorporated that with all the other pleadings. I do want to touch on a few items that was contained within our brief. First of all, Judge, the first item we'd like to talk about would be prosecutorial misconduct during the course of the trial itself. As we've set forth in our brief, Ms. Hughes, one of the prosecutors in this case, did in fact play the 911 tape. She asked questions which can be found in the transcript at page 88, and the question or questions that were asked by Ms. Hughes are, first, she says, "Now, Todd, here I'm going to play you the part where you're doing the chest compressions, and I'm just going to ask that you listen in between the chest compressions, okay?" And then plays the 911 call. "Now, Todd, did you just hear that whisper at the end of that?" He answers, "Yes." The question, "And what did you whisper?" He answers, "I couldn't hear it." "Okay, I'm going to play it again." Question, "Todd, do you whisper 'cheating whore' right there?" Todd says, "No." "So you don't remember what you whispered?" "No." "Okay, I'm going to play another clip for you." Plays the 911 call. "Do you know what you whispered there?" "No." "Did you hear that? So I'm going to play that part one more time." Next question, right there. "Do you say, 'Go to hell, cheating whore'?" Todd says, "No." "So you don't hear that?" He says, "No." "You didn't hear at 6:53, cheating whore. You didn't hear that." "I didn't hear that word. It's right at the end after you hear a ping. You don't hear, 'Go to hell, cheating whore,' and the answer is no." After the conclusion of this trial, counsel had the tape reviewed by an expert company. And the fact of the matter is that none of those statements were contained on that tape. So in looking at this, Your Honor, the question is, did Ms. Hughes intentionally, recklessly, and repeatedly use prejudicial terminology while she knew or reasonably should have known this phrase was not in the recording that was played? Were her questions distorted to get distorted testimony, making unsupported statements during her closing argument, diverting the attention away from the actual existing and presented evidence? So to prove prosecutorial misconduct, we must show that the prosecutor acted with reckless disregard, and that's contained in State versus Leadham. Also, the Iowa Supreme Court has set forth in State versus Schlitter to specifically note that conduct by a prosecutor that deprives a defendant of a fair trial is prosecutorial misconduct within the confines of the law. Further, the court specifically identified examples of prosecutorial misconduct, including questioning witnesses about others' deceit, distorting testimony, and this is the important one, making unsupported statements during closing arguments, stating the defendant lied during testimony, diverting the jury from deciding the case based on evidence, making other inflammatory or prejudicial statements about the defendant. That's what happened in this case. By asking those questions, knowing that those statements were not contained on that audio tape, I think rises to the level of misconduct. Now, I expect to hear from the government that jurors were interviewed, at least a juror was interviewed after the trial in this case, and that juror said that, well, we were on both sides of the fence, or we were undecided, meaning some probably thought that was said, some didn't think it was said, but they couldn't come together, so we disregarded it. Well, the problem is, I wasn't in that jury room, the court wasn't in the jury room, the government wasn't in the jury room. We don't know what the jurors talked about. We don't know if they actually, all of them did disregard it. The jurors have not been placed under oath and asked these questions. That has not happened. So it puts us in a position, Judge, where the only way that we can right the wrong that took place at trial at this point in time is going to be to grant Mr. Mullis a new trial in this case, along with further instruction. The next issue that I would like to talk to the court about today is going to be whether or not Mr. Mullis received effective assistance of counsel during the course of this trial. Now, Judge, Mr. Mullis has always maintained that this was an accident. He has never come out and said that this was a murder ever. Second, he never told his counsel at the time that they could concede an essential element of a crime that Mr. Mullis has been accused of committing. And what happened in this case? Well, during the opening statement, the fact that this was a murder and the jury has to figure out who did it, was conceding an essential fact or an essential element that the government would have to prove beyond reasonable doubt to the jury. Now, that's important because there's a United States Supreme Court case, McCoy versus Louisiana. And in that case, the Supreme Court, under Head Note 6, goes on to say that numerous choices affecting conduct of the trial do not require client consent, including the objections to make, the witnesses to call, and the arguments to advance. The court goes on to say, though, that counsel in any case must still develop a trial strategy and discuss it with the client. The court goes on explaining why, a lawyer needs to say why, in their view, conceding guilt would be the best option. And that did not happen in this case. To further advance that notion that it didn't happen, on July 7th of this year, Todd Mullis was involved in a probate proceeding, probate hearing that was under oath. And we've attached this as an exhibit to our brief. During that time, or during that hearing, Todd was represented by his counsel, and the estate was represented by one attorney, William Strong. Now, during the course of cross-examining Mr. Mullis, So these questions were not asked by his lawyer. They were asked by the lawyer for the other side. So during cross-examination, back July 7th of 2020, the question was asked by Mr. Strong of Mr. Mullis. And I quote, "And I believe during your criminal trial, you took the position that Amy was murdered, but it just wasn't you. Do you recall that?" Mr. Mullis, under oath, says, "I never said that." The next question. "Well, I believe that was evidence that your attorney asked you during the criminal trial. You don't recall that testimony." There's then an objection, and the question gets reread, and Mr. Mullis answers, "I never gave my lawyer the request to state that." Meaning, I never asked my lawyer to concede that this was a murder and just take one of the elements that the government would have to prove beyond a reasonable doubt out of the equation. We have it under oath. I think that with the guidance of the United States Supreme Court, what we have Mr. Mullis saying, how this case went, because once an admission to a murder is made in an opening statement, you can't put that back in the bag. That's out. The jury's already believing that this was somehow a murder and that they just have to decide who committed it. Once again, the only way that we can right this wrong is to grant Mr. Mullis a new trial. Last, I want to talk about the totality of the evidence that came in, viewed in the light most favorable to the government, which is how the court has to look at this. Was there enough to convict Mr. Mullis? And what we have to look at is what happened on November 10, 2018. Well, we know that on that day, Todd Mullis, his original plan was to go and do what's called chisel farming. He was going to go to a different property that they either rented or owned, and he was going to do some work on the ground to get it ready for the spring crops. The ground was too frozen, as it turns out, that particular day. It was too cold. Mr. Mullis then goes back to his house where he and Amy and Tristan, his 14-year-old son, have breakfast. After that, Mr. Mullis and his son Tristan decided that since he couldn't do the chisel plowing, that they would go hang heaters in the hog barn that's located on their property. Amy decides that she wants to come out and potentially help and do whatever, so she goes out as well. Amy, had a procedure a day or two before and wasn't feeling all that great. So nonetheless, she goes out. They're there, and how this barn is set up is that it is a barn that runs east and west, and there are 3 entrances into this barn. There's the main entrance on the west end of the barn, which you walk into what I call like an open office setting. It has some tools hanging there. It has what else becomes very big in this case. It has a water spigot and a garden hose in that little area. There's a window in that area that looks out down to the east so you can see into the hog barn itself. Just a few feet away is a doorway where you would enter or walk through to get in to the barn part itself. The only other entrance on the west end of the building, you would have to walk up a ramp, and it's like that because that's where semis would back up to that door that's elevated off of the ground for hogs to travel in and out of the barn. The last entrance or exit is clear on the southeast corner of the barn. This barn is about 100 yards in length for where the cattle can be. Tristan and his father were working on the west end. They were starting on the west end, going to work their way towards the east, hanging these lamps so that when they got the small hogs in, they would be warm during the winter months. Now, Amy decides that she's going to go back into the house, and somehow it comes up, I think maybe Todd asked her if she could grab the cat carrier out of the red barn, which would be located to the west and to the south of the hog barn. So Amy leaves, and they don't see her. They continue to work, and it's at least 15 minutes, if not a little bit longer, before Tristan says he's thirsty and he's going to go around the corner and get a drink of water. So he leaves to go around the corner and get a drink of water. Now, as he's standing there getting his drink, he doesn't see Todd Mullis walk by him and go out the west side door. He doesn't see Todd Mullis go up the ramp, open the hog door, and jump down to the ground. All right? The only other way this could have happened, and it's impossible that it did happen, would be that Todd Mullis would have to sprint 90 yards to the east, over to the east door. Todd Mullis would then have to exit. And bear in mind that this is 15, 20, maybe longer minutes later. Todd Mullis doesn't know where Amy is located at. So whether she's in the red shed, whether she's in the house, he doesn't have any idea. So then that means that Todd would have to sprint 100 yards back to the front or the west side of the barn, and then the red barn is located approximately 30 yards away. So they'd have to sprint 30 yards over to the red barn. He then would have to commit this criminal act that he's been accused of by finding a pitchfork or corn rake and then put it down, then sprint 130 yards back to the east to that door, sprint another 90 yards once he gets inside back to the west, start working on the heat lamps, not be out of breath, be perfectly normal, all while Tristan left to go get a drink of water and come back in. It would be physically impossible for him to do that. That's the only time that I believe that he was out of, except for maybe one other drink, which was short, that they were out of each other's eyesight as they're working in the barn. It wasn't until Tristan leaves to go find Mom that he finds Mom, yells, or speaks loudly, whatever the case may be. Todd hears, and then Todd goes over and then for that reason, and for all of the other reasons that I've talked about today, the only way to make this right for Mr. Mullis is to grant a new trial. And our reasoning and facts for the motion and arrest of judgment are the same, so I'm not going to reiterate everything for the motion and arrest of judgment. So in the end, Judge, we are asking that this court grant a new trial, allow us to proceed to trial, and present our evidence. Thank you.
Okay, Ms. Hughes, do you want to go ahead and offer the state's argument?
Yes, Your Honor. As you are well aware, Judge, a court may grant a new trial pursuant to Iowa Rule of Criminal Procedure 2.24, subsection 2, subsection B, subsection 6, when the verdict is contrary to law or evidence. The language contrary to evidence means contrary to the weight of the evidence. In ruling on a motion for new trial, the court may weigh the evidence and consider the credibility of the witnesses. In the current case, the state proved beyond a reasonable doubt all the elements necessary for murder in the first degree. The verdict was consistent with the weight of the evidence, which showed the defendant committed murder in the first degree. As Your Honor is well aware, the decision to grant a new trial is within the discretion of the court and should be exercised with caution. Your Honor, with regards to the motion, the second motion for new trial and motion in arrest of judgment filed by the defense, I will briefly talk about the 7 different issues or points that they addressed. The first one being prosecutorial misconduct. The defendant takes issue with what I indicated and what I believed then and still believe the evidence showed. But it is the state's position, Your Honor, that even if the jury did not believe that's what the tape said, I very deliberately and several times instructed the jury during closing to decide what they believed the tape stated. In fact, Judge, I told them not to listen to what I said or to what the defense attorney said, and I advised them to decide that for themselves. Additionally, Your Honor instructed the jury that questions and statements made by the lawyers are not evidence and are not to be considered as such. You not only instructed them on that, Your Honor, but you also included that in the jury instructions in writing that were given to the jury. And those are the same instructions that were given to the jury that they used in deciding their verdict. As Your Honor is well aware, a new trial based on prosecutorial misconduct is only warranted when it is so prejudicial as to deprive the defendant of fair trial. The defendant bears the burden of showing both prosecutorial misconduct and prejudice. The defendant did not do that in this case. With regards to the second issue addressed by the defense, it discusses improper expert testimony by Deputy Hemesath. First, Judge, it's the state's position that an issue such as this cannot be raised for the first time in a motion for new trial. I do agree that the defendant objected to the Google searches coming into evidence, and that was an issue that was litigated prior to trial that Your Honor appropriately ruled on. However, to the best of the state's recollection, the issue of Deputy Hemesath actually going through those searches was not objected to at the time of trial and cannot be raised now. But nonetheless, Your Honor, Deputy Hemesath's testimony was proper. The issue of the Google searches goes to the weight of the evidence and not the admissibility, if you are even talking about the actual searches. The defense properly addressed the issues they had with the Times on cross-examination, which was the appropriate way for them to challenge the evidence and to subsequently make the proper arguments that applied. But Judge, the bigger issue with regards to what the defense brings up is that the state did not offer Deputy Hemesath as an expert witness. He testified as a peace officer and as a lay witness. I know that, Your Honor, he testified regarding the Google searches. The Google searches already came into evidence because of what Your Honor ruled in a prior motion. And they came in because the state presented a letter of authenticity from Google. So the searches were coming in. Deputy Hemesath did talk about them, and that was the manner in which we decided at that time to publish them to the jury. And the defense made a big deal about the UTC time. Again, that goes to the weight and not the admissibility. The searches were relevant because of the content, not because of the time. And furthermore, Judge, the jury again was instructed by Your Honor in the jury instructions that they are to decide the credibility of witnesses. And I know Your Honor is well aware with the instructions that were given in this case and the credibility of witness instruction that's given in criminal cases all through the state of Iowa. And it indicates that to the jury that in determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. And again, the jury used those instructions when they decided their verdict. In the defendant's motion and briefly in their brief, they also talked about improper hearsay testimony, but that was not addressed in detail. But Your Honor, the state would just say that you made appropriate rulings in the pretrial motions and during trial regarding what statements were admissible. This court has not misdirected the jury in a material matter of law, nor erred in the decision of any question of law during the course of the trial. The state contends that the challenged legal rulings made by the court in the context of the trial were made correctly, and no legal grounds exist to set aside the verdict in this case due to any alleged legal error. Your Honor, I'm going to address point number 4 and 5 that counsel made together. It was 4 and 5 in the motion, and then today talking about ineffective assistance of counsel. As Your Honor is well aware, there is a controlling case from the Supreme Court of Iowa, State v. Trane, T-R-A-N-E, which is the controlling case that talks about claims of ineffective assistance of counsel. And the Supreme Court made this ruling and decided this case in October 2019. And it explicitly states in that ruling, the only avenues for raising an ineffective assistance of counsel claim are post-conviction relief and direct appeal. The claim may not be raised via a motion for new trial. Judge, based on this, these are not appropriate claims or a reason for you to grant a new trial. The sixth point that counsel talks about in his motion is the weight of the evidence was contrary to the verdict. As I stated before, the power to grant a new trial on the ground that the verdict is contrary to the weight of the evidence should be invoked only in exceptional cases in which the evidence preponderates heavily against the verdict. The verdicts of guilty in this case are not contrary to the law. The witnesses and the evidence the state presented all establish the elements of this charge. As I indicated, the evidence in this case simply does not preponderate heavily against the verdict, and there was no miscarriage of justice that resulted from the jury's verdicts in this case. Your Honor, this is not the extraordinary case where it's your job to overrule the jury's roles and verdict. Your Honor heard the testimony, you observed the state's evidence, and was able to judge the credibility of the witnesses. The evidence in this case was overwhelming, and the defendant was found guilty of murder in the first degree because that's what the state proved. The last thing that counsel talks about in his motion is that the defendant did not receive a fair and impartial trial. And I believe that's what he just briefly discussed about the totality of circumstances. Again, Judge, I believe in his motion he references prior arguments pretty much indicating that the verdict is contrary to the evidence, which we've already addressed. What counsel just did now was start giving you a second closing argument, and that is not what a motion for new trial is for. What he just indicated to you was what he believed are the facts in this case. He was indicating facts at the end of his argument, all factual determinations that were made by the jury in this case. That is not the correct avenue for a motion for new trial. We would ask that you deny the defendant's motion for new trial as to every issue that was raised.
Mr. Hamrock, it is your motion. I'll give you the last word if you have anything else you want to add to your argument.
Thank you, Your Honor. Judge, inflammatory statements. The questions that were asked on cross-examination of Mr. Mullis were highly inflammatory. And furthermore, it didn't exist on the tape. I mean, this is why the Supreme Court has created case law when there's prosecutorial misconduct to allow Your Honor to grant a new trial. And this is what it is. I mean, we have proven that. We had the burden, I know this, and based upon everything that was said, based upon the trial transcript, we know this, and based upon the questioning of the jurors that we don't have a clear answer to, I believe that prosecutorial misconduct does in fact exist. When a prosecutor asks questions, makes statements, with reckless disregard, I think that's what happened here. That's the definition, at least according to some of the case law, of what that is. Next, I went through the facts as I read through them as they came in during the course of the trial and are reported by the court reporter into the transcripts. And that's what I wanted to impress upon the court, that the facts, even in the light most favorable to the government, don't rise to the level of convicting Mr. Mullis. Well, you want to talk about a miscarriage of justice? This is it. This case is it. I mean, Mr. Mullis didn't do this. So it is to sentence Mr. Mullis would be a miscarriage of justice, and we're hoping that the court prevents that today. Thank you, Your Honor.
Thank you, counsel. Let me just address the three issues that Mr. Hamrock argued today. The first issue was prosecutorial misconduct. I will say, with respect to that issue, and perhaps touching on some other issues, today is not a day when I can take evidence and testimony and when I'm going to make factual determinations about certain things. For example, when defense says today that an independent entity of some sort reviewed that tape and determined that none of those things were said, I can't make a finding of that today. There's no evidence of that today. By the same token, there was some reference to what jurors may have said afterwards about whether they heard those same words or did not, or considered them in any way. I'm not making any findings today. There's no testimony to that effect today. And this isn't the right process to make those determinations. I am required to simply review what happened under that argument and make a determination of whether it rises to the level of prosecutorial misconduct. And both parties have talked about recklessness. I don't find that the statements or the questions on cross-examination asked by Attorney Hughes rose to the level of recklessness or to the level of prosecutorial misconduct. There was argument repeatedly made to the jury that they would have to make their own determination. And again, the jury was properly instructed as to statements by attorneys, burden of proof, those types of things. I do not find that any statements made by Attorney Hughes rise to the level of prosecutorial misconduct. The second issue argued by counsel today is ineffective assistance of counsel. And again, today is not a day where I can make factual determinations about discussions that defendant had with his counsel and whether he told counsel certain things or they told him or didn't. Understand, Mr. Hamrock, that you have provided a transcript of your client being under oath in a different proceeding, a probate proceeding, in which he did say, I did not authorize my attorneys to say those things. I understand that. But generally speaking, ineffective assistance is an issue that's typically dealt with on post-conviction relief. In this circumstance, based on the arguments that both parties have made, I do think that that is an issue that will have to be addressed on post-conviction relief. I do not find today, based on the record we have here today, that the defendant was deprived of effective assistance of counsel. The third issue argued today deals with the totality of the evidence, taking all of the evidence that came in and considering it in the light most favorable to the non-moving party, which is the state here, and defendant's argument that considering all of that evidence in the light most favorable to the state, it still was not physically possible for the defendant to have committed this act. Neither party has made any argument that the jury was improperly instructed. So we did have 12 jurors properly instructed on the law after a lengthy trial who unanimously agreed to a finding of guilt. Ms. Hughes recited the law as it pertains to the burden today and what I have to consider, and I think she properly recited the law. I would say I think that I'm actually required, or at least that I should, independently weigh the evidence and consider credibility as it pertains to a motion for new trial. If the verdict is contrary to the weight of the evidence, the defendant is entitled to a new trial. I cannot say that the evidence in this case or that the verdict is contrary to the weight of the evidence. As to the defendant's motion for new trial and motion in arrest of judgment, I will deny those motions in their entirety. We will go ahead and proceed with sentencing at this time. We have not had, I don't believe, a pre-sentence investigation. Typically, we don't have one for a Class A felony. And I will take argument from counsel to start. Ms. Hughes, do you want to make argument on behalf of the state?
Yes, Your Honor. Obviously, Your Honor knows that the defendant was convicted of murder in the first degree, which carries a sentence of a mandatory life imprisonment without parole. Judge, you heard the evidence. You know what the defendant was charged with and what he was found guilty of. We would ask you to sentence the defendant accordingly.
Mr. Hamrock, do you want to make argument on behalf of your client?
Well, Judge, in a Class A felony, there's not a lot of argument to be made, so the court would go ahead and impose sentence.
Your Honor, may I say something?
Yes.
Thank you, Your Honor. May it please the court really doesn't have much discretion in this case other than in one area. That area is death of victim restitution. As the court is aware, that is a mandatory minimum $150,000. This case is such where that would not be justice. This individual came into court at the time of bond hearing and said he had the ability, the cash, to post $1 million against the bond. It is appropriate that this court, at this time, make that $1 million that he has available the death of victim restitution, because that's the only thing I think is going to really hit home with this individual. Yes, he has to go to prison for life, but this trial was about greed and jealousy. The greed had to do with his farm and his money. So to really hit home, Judge, it would be appropriate for that money that he says he had available to go to death of victim restitution. Thank you.
Thank you. Mr. Mullis, you have the right to speak today if you'd like to. You're not required to. Your attorney has spoken on your behalf. This is the only chance you'll get to speak today before I pronounce judgment. Is there anything you would like to say today?
I did not do this. This is supposed to be America where you have a fair chance of proving your innocence. But you shouldn't have to prove your innocence. Instead of the other way around. I thought it was guilty until, or not, innocent until proven guilty. I feel this is the other way around. And I was a faithful and loving husband, and I never did this.
Okay, thank you, sir. Mr. Hamrick, do you have anybody else that would like to speak on behalf of your client?
No, Judge.
Are there any victims that wish to be heard today?
Not live testimony, Your Honor. The state did file a victim impact statement, and we would just ask that Your Honor read that.
Okay. And there is a victim impact statement in the court file. I have read that, and I have conferred with counsel to make sure that they have had the opportunity to see that, and both parties have had the opportunity to see the victim impact statement. I will take that into consideration as if it were offered here live at the sentencing hearing. Defense counsel indicated that the sentence in this case is mandatory. He's right. It is mandatory. There's really no discretion as to the punishment handed down. According to the statute, Mr. Mullis, for the charge of murder in the first degree pursuant to Iowa Code Section 707.2, you are sentenced to life in prison with no opportunity for parole. There will be no fine issued. You'll be required to submit a DNA sample to the state of Iowa. The reasons for my sentence today are primarily the statutory requirement, the fact that there is no discretion. I will also require you to pay a victim restitution to the victim or to the estate of the victim in the amount of $150,000. You will be obligated to pay the court costs associated with this proceeding. You do have the right to appeal from this judgment. Written notice of appeal must be filed within 30 days of today's date. By statute, according to Iowa Code Section 811.1, subsection 2, you cannot be admitted to bail in the event of appeal. Is there anything else the state knows of that we need to cover here today?
Nothing further, Your Honor, sorry.
Mr. Hamrock, anything else that you need to cover on the record today?
No, Judge.
Okay, we'll stand adjourned and close the record. Thank you, everyone.